Mr. President, members of the court, good morning. I will address children. The Gambia has chosen to make children the focus of this presentation because children are central to the crime of genocide. The 1948 Convention is fundamentally about the protection of human groups. And if a group is to continue, if it is to survive, it will be through its children. Raphael Lemkin understood this. That is why he addressed children and matters of birth in Chapter 9 of Axis Rule. The drafters of the 1948 Convention understood the centrality of children to genocide as well. That is why two of the actus reus of genocide set out in Article 2 are specific to children, imposing measures intended to prevent births within the group and forcibly transferring children of the group to another group, under paragraphs D and E. And of course, children can be and are victims of the acts of genocide described in paragraphs C, A, B, and C. The Gambia agrees with the interveners who have rightly placed significant emphasis on children. It agrees entirely with the submission of Ireland, which stated as follows: where there is evidence that children of the protected group have been particularly targeted, or that the conduct targeting the group made no distinction between child and adult members of it, certain conclusions can be drawn. As children are essential to the continued existence of any human group, acts constituting the material elements of genocide directed at or without making distinction for child members of the group will have an obviously significantly greater impact on the resilience and ultimate survival of the group than the same acts directed at a similar or larger number of adult members. It therefore follows that certain reasonable inferences can be drawn from acts directed against or failing to distinguish child members of the group. Mr. President, Myanmar killed the children of the Rohingya group, often in unimaginably cruel ways. The evidence is overwhelming. The horrors go on and on and on. Yesterday, during the Gambia's presentations on just 7 of the hundreds of Rohingya villages that have been the subject of these proceedings, you heard a fraction of it. You heard accounts like those which caused the OHCHR to report that victims who ranged in ages from newborns to teenagers included children who were killed by live ammunition or stabbed while at home, while fleeing to safety, or while in farms or fields. You heard testimonies matching those which caused the UN Special Rapporteur to report young children being thrown into fires. And you heard a great many examples of the targeted killings and other abuses of Rohingya children, like those underpinning the UN fact-finding mission's conclusion that children were subjected to serious human rights violations, including killing, maiming, and sexual violence. We will not belabor the point. Suffice to say, we could review with you even more evidence that is equally credible and terrible, both in relation to the villages discussed yesterday and many, many more. But we feel the point has been adequately made. It is, we say, incontestable that Myanmar did in fact systematically murder the children of the Rohingya group. It did so intentionally, it did so knowingly, it did so deliberately, and it did so on a scale that is, or ought to be, unimaginable. Therefore, unlike the presentations yesterday, the focus of my presentation is not evidential. Instead, I will address the legal significance of the evidence before you, particularly as it relates to the killings and other grave abuses to which Myanmar subjected Rohingya children. Where appropriate, I will refer to the evidence in order to discuss how it bears upon the legal determinations that you are called upon to make. However, the evidence per se will not be my focus. I begin with the actus reus of genocide, and in particular, killing members of the group under Article 2, Paragraph A. Myanmar argues that Article 2, Paragraph A does not apply to the legitimate killing of insurgents or terrorists in battle, in an armed conflict, or in a law enforcement operation, and does not extend to civilian deaths caused by such operations if they are exclusively directed at legitimate targets and the civilian casualties are not caused deliberately. Myanmar's intentional killing of Rohingya children in the circumstances and in the manner we heard yesterday bears directly on this defense. Its targeted killings of the youngest of the Rohingya group, including those not yet born, lacked any conceivable legitimate objective, military or otherwise. They were not carried out in the context of military or law enforcement operations. They were not directed at combatants. Instead, they were directed at the Rohingyas most helpless. Put simply, they foreclose Myanmar from being able to argue with any credibility whatsoever that Rohingya deaths were, in the words Myanmar used in the 7th paragraph of its rejoinder, that they were just collateral casualties of fighting between the Myanmar security forces and ARSA. That is false, manifestly so. And the same is true with respect to any similar argument in regard to the causing of serious bodily or mental harm within the meaning of Article 2, Paragraph B of the Convention. Mr. President, the targeting of Rohingya children has particular relevance for the Court's consideration of Article 2B, as it held in Croatia v. Serbia. For harm to be serious for purposes of that paragraph, it must be such as to contribute to the physical or biological destruction of the group, or in whole or in part. The Court's consideration of whether an act contributes to the physical or biological destruction of a group requires taking into account not just the nature of the relevant act itself, but also the specific circumstances of the victims. This applies with special force in relation to crimes committed against children, as happened here, in view of their heightened vulnerability. And the same is the case with respect to the deliberate infliction of conditions of life calculated to bring about its physical destruction in whole or in part under Article 2C. The acts that will qualify as the actus reus of genocide under this paragraph must necessarily take account of the particular characteristics of the members of the group that are impacted by the relevant conditions. Here, Rohingya children of all ages, including infants and newborns, were subjected not only to Myanmar's efforts to deprive the Rohingya of food and health care prior to the clearance operations, but also to the atrocious attacks on their villages and during their forced displacement, where they lacked food and shelter. I need not dwell upon the fact that children are especially vulnerable to such privations. Mr. President, this brings me to the issue of genocidal intent. Here, we respectfully submit the targeting of Rohingya children is of singular importance. The acts described yesterday qualify as acts of extreme brutality, one of the indicators of genocidal intent, as has been clearly shown by my colleague, Ms. Ho. So too, the fact that they were frequently committed in conjunction with acts of sexual violence, another indicator of genocidal intent, as explained by Ms. Paspinocha. But that is not their only relevance to genocidal intent. Myanmar's targeting of Rohingya children demonstrates that the members of the group were targeted because of their membership in the group. There is no other conceivable explanation. And the evidence that they were targeted on a significant scale, as is unquestionably the case, precludes any basis for concluding they were targeted for any other reason. Further, what qualifies as a substantial part of the group depends on the relevant circumstances, including whether a specific part of the group is emblematic of the overall group or is essential to its survival, as the ICTY Appeals Chamber held in Kursich. In that connection, Rohingya children form a substantial part of the Rohingya group, and thus their targeting is compelling evidence of Myanmar's intention to destroy the group as such, at least in part. That is undoubtedly so, as the physical destruction of the Rohingya as a group would be assured if the next generation were destroyed, as Myanmar sought to do when it systematically shot, stabbed, burned, and drowned Rohingya children of all ages. The targeting of Rohingya children is also highly probative of planning and organization, another indicator of genocidal intent. Mr. President, as you heard, Myanmar's targeting of Rohingya children was not confined to isolated incidents. They were a ubiquitous occurrence during the clearance operations. Médecins Sans Frontières estimates that between 734 and 2,109 children died during the clearance operations or were killed during flight to Bangladesh. And those are just the children under the age of 5. The Tatmadaw deliberately killed children in each of the villages that was addressed yesterday, and it did so in a great many more. These atrocities were committed in different geographical areas and by different military units, all subject to a common command structure. It is fair to say that the killing of Rohingya children is one of the clearance operations' hallmarks. In these circumstances, it is impossible to avoid the conclusion that this was planned and directed from above. Mr. President, this brings me to 3 more indicators of genocidal intent and their relation to the Rohingya children. The vicious race-based discrimination to which the Rohingya are subject, and Myanmar's propagation of extreme anti-Rohingya hate speech and its toleration for such public expression by others. Ms. Paspinocha and Mr. Suleiman reviewed the relevant evidence on Monday. What they described shines a revealing light on the question of how such widespread depravity could be perpetrated. It is not a coincidence that the Tatmadaw soldiers who committed such heinous crimes against the youngest of the Rohingya, even Rohingya who had yet to be born, in Mingi, in Chapin, in Maungnu, and in many other Rohingya villages across northern Rakhine State, and who wrenched infants from their mother's arms and flung them into flames, had long been subjected to the calumny that those Rohingya children's mere birth was a threat of the highest order. That message had been communicated by the Tatmadaw's leadership and its allies through their incessant propaganda about the exploding birth rates and about Bengalis spreading like weeds. The message was received. The message was understood. And when the Tatmadaw arrived at Mingi, at Chapin, at Maungnu, and at a host of other Rohingya villages, it was tragically, obscenely implemented. Mr. President, the bottom line is that the intentional, deliberate killing of Rohingya children on a scale as massive as happened here is irrefutable proof of Myanmar's specific intent to destroy the Rohingya as a group as such. It can only be understood as reflecting that intention. It is, put simply, an indicator of genocidal intent par excellence. As the ICTR found in Akayesu, evidence that even newborn babies were not spared reflected an intention to wipe out the Tutsi group in its entirety. That is true for the Rohingya as well. The killing of Rohingya children shows that members of the Rohingya group were targeted because they were Rohingya. In the words of Akayesu, Myanmar did this to wipe out the Rohingya as a group. Mr. President, thank you for your kind attention. I ask that you invite Ms. Alamin to